Article 5. A carrier shall be at liberty to surrender in whole or in part all or any of his rights and immunities, or to increase any of his responsibilities and obligations under this convention, provided such surrender or increase shall be embodied in the bill of lading issued to the shipper. The provisions of this convention shall not be applicable to charter parties. But if bills of lading are issued in the case of a ship under a charter party, they shall comply with the terms of this convention. Nothing in these rules shall be held to prevent the insertion in a bill of lading of any lawful provision regarding general average. Article 6. Notwithstanding the provisions of the preceding articles, a carrier, master or agent of the carrier, and a shipper shall, in regard to any particular goods, be at liberty to enter into any agreement in any terms as to the responsibility and liability of the carrier for such goods, and as to the rights and immunities of the carrier in respect of such goods, or his obligation as to seaworthiness, so far as this stipulation is not contrary to public policy, or the care or diligence or his servants or agents in regard to the loading, handling, stowage, carriage, custody, care and discharge of the goods carried by sea, provided that in this case no bill of lading has been or shall be issued, and that the terms agreed shall be embodied in a receipt, which shall be a non-negotiable document and shall be marked as such. Any agreements entered into shall have full legal effect, provided that this article shall not apply to ordinary commercial shipments made in the ordinary course of trade, but only to other shipments where the character or condition of the property to be carried, or the circumstances, terms and conditions under which the carriage is to be performed, are such as reasonably to justify a special agreement. Article 7. Nothing herein contained shall prevent a carrier or a shipper from entering into any agreement, stipulation, a condition, reservation or exemption as to the responsibility and liability of the carrier or the ship for the loss or damage to, or in connection with, the custody and care and handling of goods prior to the loading on, and subsequent to, the discharge from the ship on which the goods are carried by sea. Article 8. The provisions of this convention shall not affect the rights and obligations of the carrier under any statute for the time being in force relating to the limitation of the liability of owners of seagoing vessels. Article 9. The monetary units mentioned in this convention are to be taken to be gold value. Those contracting states in which the pound sterling is not a monetary unit reserve to themselves the right of translating the sums indicated in this convention in terms of pound sterling into terms of their own monetary system in round figures. The national laws may reserve to the debtor the right of discharging his debt in national currency according to the rate of exchange prevailing on the day of the arrival of the ship at the port of discharge of the goods concerned. Article 10. The provisions of this convention shall apply to all bills of lading issued in any of the contracting states. Article 11. After an interval of not more than 2 years from the day on which the convention is signed, the Belgian government shall place itself in communication with the governments of the high contracting parties which have declared themselves prepared to ratify the convention, with a view to deciding whether it shall be put into force. The ratifications shall be deposited at Brussels at a date to be fixed by agreement among the said governments. The first deposit of ratifications shall be recorded in a perseverable signed by the representatives of the powers which take part therein and by the Belgian Minister for Foreign Affairs. The subsequent deposit of ratifications shall be made by means of a written notification, addressed to the Belgian government and accompanied by the instrument of ratification. A duly certified copy of the perseverable relating to the first deposit of ratifications, one of the notifications referred to in the previous paragraph, and also of the instruments of ratification accompanying them, shall be immediately sent by the Belgian government through the diplomatic channel to the powers who have signed this convention or who have acceded to it. In the cases contemplated in the preceding paragraph, the said government shall inform them at the same time of the date on which it received the notification. Article 12. Non-signatory states may accede to the present convention whether or not they have been represented at the International Conference at Brussels. A state which desires to accede shall notify its intention in writing to the Belgian government, forwarding to it the document of accession, which shall be deposited in the archives of the said government. The Belgian government shall immediately forward to all the states which have signed or acceded to the convention a duly certified copy of the notification and of the act of accession, mentioning the date on which it received the notification. Article 13. The high contracting parties may at the time of signature, ratification or accession declare that their acceptance of the present convention does not include any or all of the self-governing dominions or of the colonies, overseas possession, protectorates or territories under their sovereignty or authority, and they may subsequently accede separately on behalf of any self-governing dominion, colony, overseas possession, protectorate or territory excluded in their declaration. They may also denounce the convention separately in accordance with its provisions in respect of any self-governing dominion, or any colony, overseas possession, protectorate, or territory under their sovereignty or authority. Article 14. The present convention shall take effect in the case of the states which have taken part in the first deposit of ratifications, 1 year after the date of the protocol recording such deposit, as respects the states which ratify subsequently or which exceed, and also in cases in which the convention is subsequently put not effect in accordance with Article 13. It shall take effect 6 months after the notifications specified in paragraph 2 of Article 11 and paragraph 2 of Article 12 have been received by the Belgian government. Article 15. In the event of one of the contracting states wishing to denounce the present convention, the denunciation shall be notified in writing to the Belgian government, which shall immediately communicate a duly certified copy of the notification to all the other states, informing them of the date on which it was received. The denunciation shall only operate in respect of state which made the notification, and on the expiry of 1 year after the notification has reached the Belgian government. Article 16. Any one of the contracting states shall have the right to call for a fresh conference with a view to considering possible amendments. A state which would exercise this right should notify its intention to the other states through the Belgian government, which would make arrangements for convening the conference. Done at Brussels. In a single copy, August 25, 1924. Protocol of Signature. William, at the time of signing the International Convention for the Unification of Certain Rules of Law relating to bills of lading, the plenipotentiaries whose signatures appear below have adopted this protocol, which will have the same force and the same value as if its provisions were inserted in the text of the convention to which it relates. The high contracting parties may give effect to this convention either by giving it the force of law or by including in their national legislation in a form appropriate to that legislation the rules adopted under this convention. They may reserve the right 1. To prescribe that in the cases referred to in paragraph 2, c2p of Article 4, the holder of a bill of lading shall be entitled to establish responsibility for loss or damage arising from the personal fault of the carrier or the fault of his servants which are not covered by paragraph 2. To apply Article 6 insofar as the national coasting trade is concerned to all classes of goods without taking account of the restriction set out in the last paragraph of that article. Done at Brussels. In a single copy, August 25, 1924. Signatories: Germany, Belgium, Chile, Spain, Estonia, United States of America, France, Great Britain, Hungary, Italy, Poland and the Free City of Danzig, Romania, Kingdom of the Serbs, Croats and Slovenes.